So much has been said about Trump's New York trial. Most of what is said has very little to do with what the jury saw, which caused them to find Trump guilty. This video is about the evidence which was presented by Donald Trump in the courtroom to show that he was not guilty of any of the 34 charges. This video is the second part in a three-part series. In the first part, went over the evidence that was presented by the prosecution. A lot of the defense's arguments are directly countering those made by the prosecution in the last part. I would recommend watching that first if you are not heavily familiar with the case. It will make this video make much more sense. Everyone who watched that video is already familiar with this house. This is the House of Guilt, which was constructed by the prosecution in the previous part. There are 4 walls, which are all constructed out of the evidence from the trial, and all 4 need to be properly solid in order for the jury to finish the house by putting the metaphorical roof on by finding Trump guilty. It is the defense's imperative to knock the walls down and convince the jury that the evidence is flimsy. If they can convince just one juror that one wall doesn't have the evidence to prove Trump guilty beyond a reasonable doubt, then Trump cannot be found guilty. So, put yourself in the seat of a juror, keep an open mind, and watch the defense's strongest arguments as to why Trump should not have been found guilty. Let's once again start with the garden of the house. The garden doesn't hold up the roof and shouldn't matter directly for finding guilt or innocence, but it does colour lots of the rest of the story. Stormy Daniels testified that she was, at best, coerced into having an affair with Trump in 2006, and years later, Trump sent a goon after her to threaten her and to keep her quiet. Daniels then signed an NDA with Trump's fixer, Michael Cohen, to protect her and her daughter. The defense, on the other hand, say that she is lying about having relations with Trump as part of an extortion scheme to get money. Either way, it doesn't make the conduct that Trump is accused of legal, which is why the evidence is in the garden and not on the walls of the building. But it certainly looks better for Trump if he is an innocent victim of extortion, as opposed to paying an adult entertainer hush money to cover up him cheating on his wife. So, it's clearly in the defense's best interest to make Stormy Daniels seem as non-credible and generally just as bad as possible. Here is how they did that. The defense pointed to some inconsistencies in Daniels' narrative. Daniels has told her story multiple times, the first time in 2011 and multiple times since then. Each time, some things are different. In 2011, she said that Trump directly asked her to dinner. She later said it was Trump's bodyguard Keith Schiller who asked for Trump. She also said in 2011 that she had dinner, but now claims that they never ate. She used to say that she walked to Trump's hotel, but at trial she says she walked halfway and then took a car for the other half. It's worth noting that the 2 hotels are about a block apart. There was also an inconsistency on where Trump was when she first entered the room. The prosecution claims that she agreed to the NDA for her own safety after she was threatened by a man sent by Trump. On cross-examination, the defense grilled Daniels on this encounter and brought up some more inconsistencies.
And you claim that in 2011, after you sold your story to In Touch, you were approached by a man in a car?
Yes.
And according to you, this man threatened you and your infant daughter?
Correct.
He threatened your lives, you said?
He implied it, yes.
In 2011, when this supposedly happened, you didn't tell anybody about this supposed threat to yourself and your baby daughter?
I told my close friends.
Well, according to you, that threat happened while you were on the way to exercise class?
Correct.
And right after it supposedly happened, you say you actually went to that exercise class?
I didn't go to the class. I went to the restroom in the class.
You went to the restroom. After that, you went to the class, right?
No, I did not return to exercise class. I waited until they were done with the class.
But you not tell anybody at that class? You didn't tell your instructor that you had just supposedly been threatened?
No, I lied to her and told her that my baby had a blowout in her diaper. That is why I was crying in the bathroom.
You didn't tell anybody else in the class about it?
No, they left before I came out of the bathroom anyway.
You never before this instance said you were crying about it, did you? That was the first time you ever said that?
No, it's not.
1 minute. Isn't it true that you wrote about this in your book, right?
Yes.
And you said that you went right to the bathroom and you must have looked crazy because the instructor yelled after you. Are you okay? Right?
Correct.
You said you responded, "She had a blowout, I'll be there in a minute."
I was afraid to tell anyone. I was alone in the bathroom. I held my baby close instinctively, covering her head as I stared at myself in the mirror.
You were shaking still, but less now, correct?
Correct.
You didn't say I was lying and the instructor saw me crying, did you?
Yes, I did. I said she had a blowout. That is a lie. That is not telling the truth.
Then, in fact, in the same book, you said that I went and did the class, told no one what happened in the parking lot, right?
Yes, I went to the class afterwards. Everybody was gone. Told my instructor that she had an accident, and that was it.
When you wrote, "I went and did the class," you didn't mean to say, "I did the exercise class"?
It was incorrect. I did not do the class.
So you wrote a book saying that you did the class, and now you are saying you didn't do the class.
I did not do the class. There is no way I could have possibly done exercises as scared as I was.
In any case, you didn't tell anybody in the class about it, right?
No, but I wasn't close with those women anyway.
You didn't call the police, did you?
No.
You didn't even tell your husband, who was the father of the child who you claim was threatened, right?
Correct.
The first time you publicly told this story that was about a supposed threat to your life was in 2018, right?
I don't remember.
Well, it was on the Anderson Cooper show, wasn't it?
I know I had told it before that because a colleague told it in an interview she did about me. She was the only person that I called that day or the next day after it happened.
At the time, though, in your book, you said you told no one, right?
Yes.
Now you claim you told a colleague?
Afterwards, not that day.
But you wrote you told nobody about this story?
Which I said in the book, as you just read, I told nobody about it that day or the days that followed.
This is actually pretty representative of how every inconsistency went on cross-examination. The defense would show a past interview or document that is contradictory to her current account, and Daniels would say that the phrasing in the past document is being misinterpreted and that it supports her current account. All in all, she did a pretty good job in not giving the defense any clear wins on cross-examination. In this instance, however, the defense found an audio recording between Michael Cohen and Daniels' former lawyer Keith Davidson, where Davidson says that Daniels, her agent, and her new lawyer, Michael Avenatti, invented the encounter with the man in the car.
Avenatti's lying his ass off, as you know, and I know, and Gina knows. And Stormy knows. And Stormy's lying. Right?
Are you speaking with Gina?
On occasion. We went a long time without speaking. You know, Gina brought Stormy to Avenatti. And we went a long time without speaking. And now that Avenatti has really driven a wedge, a serious wedge, in between Stormy and Gina, Avenatti is leaning on Gina, saying, you know, basically, we know we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things.
But why would Daniels lie about the encounter in the first place? The defense posits that it's to cover up her real reason for wanting the NDA and later publicizing her story anyway. The defense say that Daniels sold her story to make money. Here, they quiz her on the timing of the publication.
In 2011, your story wasn't worth much money?
I don't know what it was worth. I turned down many offers.
You turned down or tried to get $15,000, you couldn't get that?
Correct.
Now, in 2016, you say that you were afraid, but the story was worth a lot of money for you now, right?
Correct.
And you then had Gina Rodriguez go out and try to sell the story, right?
Correct. I didn't care for how much. I just wanted the story out there, which is why I had a press conference set up for free.
And you didn't give a free press conference, did you?
I didn't have to.
You were looking to extort money from President Trump, right?
False.
Well, that's what you did, right?
False.
When you say this fear that you say you were under in 2016 is based on the supposed incident that supposedly took place 5 years earlier that you still hadn't told anybody publicly about, right?
It was not a supposed incident. It was a true incident. I had told a lot of people.
You hadn't told your husband, right?
No.
And then so because you had that fear, you decided to do exactly the opposite of what that person had told you to do, right?
Correct.
So you weren't really very scared, were you?
I was terrified. I decided to change my tactic. It was a new ball game. There's a big difference between a reality TV star and someone running for office.
The truth is, you saw your opportunity to make it known. You had Gina Rodriguez try to sell your story to the National Enquirer.
I saw my opportunity to get the story out. I didn't put a price tag on it. That is why I did every interview for free.
At this point, you were asking for money. You wanted money from President Trump, right?
No.
You weren't asking for money in 2016?
I never asked for money from President Trump.
You asked it from Michael Cohen, right?
No. I never asked for money from anyone in particular. I asked for money to tell my story.
And that's what you're asking in 2016 was for money to be able to tell your story, right?
I was asking to sell my story to publications to get the truth out.
But you entered into a negotiation over a non-disclosure agreement, right?
My attorneys did, yes.
And that was your choice, right?
No response from the witness.
Well, you made the decision that you wanted your lawyers to do that, right?
I accepted an offer.
That was your choice, right?
Not necessarily. I wanted to do a press conference.
You would prefer to do the press conference and get no money over making money. Is that what you're saying?
Absolutely, if it got the story out.
So why didn't you do that?
Because we were running out of time.
You were running out of time to get money, right?
No, to get the story out.
You could have gone out any day of the week, could have walked out of your apartment, out of your ranch home, and given a press conference, right?
I could have.
But you chose not to, right?
I chose to be safe.
You chose to make money, right?
No response from the witness.
Right.
I chose to take the non-disclosure.
Even Michael Cohen said that at the time he thought it was an extortion attempt. Cohen also recorded a call with Davidson where Davidson claimed that Stormy Daniels may have been ever so slightly interested in the money.
I just didn't want you to get caught off guard, and I wanted to let you know what was going on behind the scenes. And I would not be the least bit surprised if I wouldn't be the least bit surprised if you see in the next couple days that Gina Rodriguez's boyfriend goes out in the media and tells a story that Stormy Daniels, in the weeks prior to the election, was, basically yelling and screaming and calling me a pussy.
Can I ask you a question? Right.
No, hold on 1 second. I wouldn't be the least bit surprised if he comes out and says, you know what? Stormy Daniels, she wanted this money more than you can ever imagine. I remember hearing her on the phone saying, you fucking Keith Davidson, you better settle this goddamn story, because if he loses this election, and he's going to lose, if he loses this election, we lose all fucking leverage. This case is worth zero, and if that happens, I'm going to sue you because you lost this opportunity. So settle this fucking case. That's a far cry from being, bullied and pushed into settling a case.
Right.
Daniels also monetizes her position of being publicly opposed to Trump. She sells a variety of anti-Trump merchandise on her website and has gone on a strip club tour, which she named after Trump's campaign slogan. She says that back in the day, when she was stripping, it was generally middle-aged white men who would come and see her. Nowadays, however, there are many more women, gay couples, immigrants, and other social liberals who despise Trump. She has also made money from her book, a documentary based on the book, and she charges people to attend viewing parties where they watched the documentary with her. She also has one other, rather strange source of income.
And there's another way you're making money now, which is by telling people that you have the ability to communicate with ghosts and dead people, right?
I work on a television show called, well, the title had changed, but it used to be called Spooky Babes.
Well, my question was, are you making money by telling people that you have the ability to communicate with ghosts and dead people?
Well, I am making money. Well, I haven't made any money yet, but the idea is to make money on a television show about the paranormal and UFOs and the unexplained.
Well, you have made a show and podcast claiming that you can speak to dead people, right?
I have been on lots of podcasts.
Well, my question.
Which podcast are you referring to?
Are you saying you have not made a show or a podcast telling people that you can speak to dead people?
Yes, we are talking about the paranormal, yes.
And you also claimed that you lived in a house in New Orleans that was haunted and that the spirits that are in the house attacked your boyfriend and held him underwater, right?
Yes, so the house has some very unexplained activity. We brought in experts, people to measure the electromagnetic fields, the religious experts, scientists, people to check for gas leaks. So yeah, it was a lot of interesting and unexplained activity. So I created a whole entire show. A lot of the activity was completely debunked as, a giant opossum that was under the house, for instance.
And you have been making money off of your claim that you are a medium and that you can talk to the dead, right?
I am making money I am part of a ghost hunting team that we go into locations, yeah.
And you read tarot cards for clients, correct?
Yeah, a lot of my fans like to do things called high tea and tarot with Stormy Daniels, and we read tarot cards together.
And you charge people for that, right?
Yes.
And you claim to be able to speak to people's dead relatives, right?
I make them agree that it's all entertainment, right.
And that's what you charge them for?
Yes.
But you tell people that that's what you can do, right? Speak with their dead relatives, right?
Yes.
And that's what you have made money off of, right?
One of the ways, yes.
Finally, Daniels has at least one really, really good reason to hate Trump. She owes him hundreds of thousands of dollars. There were numerous civil lawsuits between Daniels and Trump, and the net result of them all is that Daniels owes Trump about $550,000 in legal fees. She has refused to pay it since she thinks it's unfair. So the defense say that Daniels is lying about the affair and about the encounter with the man in the parking lot, that the whole NDA agreement was just an extortion scheme to get some quick money, and that Daniels has kept the lie going since she hates Trump and makes money from being opposed to him. Moving to the building, we're going to start with wall number 1. Here the prosecution put forward evidence that the information in the documents is factually false, making them false business records. The documents claimed that Cohen was getting paid for work he was doing for Trump pursuant to a retainer, and the defense say that this is accurate. During 2017, Michael Cohen was the personal attorney to President Trump, and the defense claim that he was paid for that. The amount of work that Cohen did for Trump that year is certainly relevant to help us determine if it is pay for services rendered or a way of hiding the reimbursement. Here is how Cohen quantifies the amount of work he did that year on direct examination.
I want to talk to you a little bit about the work that you did in 2017. Any work that you did with respect to your role as personal attorney and personal counsel to President Trump. Did you do, in the year 2017, any work for Mr. Trump or for his wife Melania Trump?
Minimal.
And can you just give us some examples of the minimal work that you did in 2017 for them?
There was a matter that dealt with an individual by the name of Summer Zervos. I was working with Mark Kasowitz on that, and so I had spoken with Mr. Trump in the Oval Office and provided him some documents that Mr. Kasowitz had given to me to pass along. As far as Melania, I think it had to do with some trademarks or maybe even a Madame Tussauds agreement.
So let's break both of those down. In terms of the work that you did for Mrs. Trump related to Madame Tussauds or the trademark, can you characterize the extent of that work for Mrs. Trump?
I reviewed an agreement that Madame Tussauds sent to her that was to create her likeness and image for their museum.
Was it a substantial amount of time that you spent on that?
No, ma'am.
And did you send a bill or an invoice to Mr. Trump or to the Trump Organization for that work?
No, ma'am.
Why not?
Well, one, I didn't expect to be paid on it, but it wasn't enough work to have me send an invoice.
And you mentioned Summer Zervos. Who was handling that matter substantially for Mr. Trump?
Mark Kasowitz.
So that was an outside attorney, not yourself?
Correct.
How would you characterize the amount of work that you did generally on that matter, if any?
Very minimal.
Did you ever bill Mr. Trump or the Trump Organization for that minimal work that you said that you did on that?
No, ma'am.
Why not?
Again, it wasn't any substantial work. Mr. Kasowitz was actually doing the work on that. Plus, I didn't expect to be paid.
Now, from time to time, withdrawn. From time to time, did you receive some emails from Alan Garten, who was the general counsel of the Trump Organization, about particular matters here and there that he might want you to look into?
Yes.
And did you consider that work that he sent you legal work?
No.
And regardless of what type of work it was, in terms of things that he sent you, what was the extent of any work that you did on those matters?
Also minimal.
And did you send a bill or an invoice either to Mr. Trump or to the Trump Organization for that work?
No, ma'am.
And why not?
Because the same reasons as stated, I didn't expect to be paid and it was very minimal work.
If you had to characterize or estimate the number of hours that you spent in the year 2017 doing any sort of work, legal or these quasi-legal matters, what would be the total number of hours that you would estimate?
Less than 10.
Now, did you bill for any of those matters?
No, ma'am.
Was the $420,000 that you received from Mr. Trump and from the Revocable Trust, did that have anything to do with the minimal amount of work that you did for Mr. Trump in 2017?
No, ma'am.
After that, it was the defense's turn to question Cohen. Their goal was to show that substantially more work was done than Cohen just admitted to. Let's see how they did.
You changed roles, so you leave the Trump Organization and you start as President Trump's personal attorney. You continue to do what you were doing in February of 2017, right? Helping President Trump with his personal legal issues, right?
Yes, sir.
You had a matter with Mark Kasowitz representing President Trump, right?
Yes, sir.
You and he were actually lead counsel on that case, right?
I think Mark Kasowitz was lead counsel.
Well, let's take a look at B-176 just for you, the court, and the parties. So isn't it true that both you and Mr. Kasowitz were both lead counsel on that matter?
Yes, sir.
And that was, at the time, a relatively active matter that was taking a fair amount of your time, and it looks like Mr. Kasowitz's time, right?
Yes.
So one of the things that you did as President Trump's attorney was to help him find a lawyer to actually work the case, right?
Yes.
So in the case that we just talked about with Mr. Kasowitz, you were co-lead counsel with him, right?
Yes, sir.
But in some other cases, you maybe wouldn't have handled the case yourself if it wasn't your area of expertise. But you would represent President Trump in getting a lawyer to help him, right?
Correct.
And do you recall doing that in January and February of 2017 for President Trump?
Yes.
For example, there were issues at the time with reporters potentially making defamatory statements against President Trump, right?
Yes, sir.
And you helped, that was part of your job, right? To help with that?
Yes, sir.
And you have met regularly with counsel, including Mr. Kasowitz, in February as well, on not only the case you were lead counsel on, but some other matters as well, right?
Yes, sir.
And there was, just so the jury understands and to help us understand, that was a case that actually had legal filings that had to be made, right?
Yes.
So it wasn't just like a threat of litigation, there was ongoing litigation with legal filings, right?
Yes, sir.
And you were part of that?
Yes.
Your role changed, is that fair? Is that what you said?
Yes.
Okay. So certainly, talking about January and February, you were actively a part of that, correct?
Yes.
And then the filings in March, you helped with the filings, correct?
I reviewed the documents, yes.
Well, is reviewing the documents helping with the filings?
Yes, sir.
All right. Do you recall helping President Trump even serving subpoenas on government agencies, like helping figure out how to serve a subpoena on a State Department? Do you recall helping with that?
No, sir.
Well, let's take a look at B-237 and just review that for the parties and the court. So, do you recall working with Mr. Kasowitz around subpoenas that had been issued, including the State Department?
I received the email from them, yes.
Well, when you received an email like that and you were President Trump's attorney, would you have known something about it?
Yes.
So that was just my question, whether that was one of the things that you were doing at that time, was helping President Trump with that type of issue.
Yes, sir.
Now, in May of 2017, a special counsel was appointed named Robert Mueller, right?
Correct.
What, if any effect did that have on your attorney-client relationship with Mr. Trump, if anything?
It did not.
So at some point, though, later in the year, did the fact that there was a special counsel investigating President Trump affect your relationship with President Trump?
Yes, sir.
And that's because there were false claims made by you?
Yes, sir.
Now, President Trump appointed or named Mr. Kasowitz, at least initially, to be his lawyer for that, right?
Correct.
And you were part of that process, right? Well, the process of selecting Mr. Kasowitz, did you play a role in that?
No, sir.
How did you find out about it?
I don't recall.
Were you happy, sad, or indifferent that Mr. Kasowitz had been appointed as President Trump's personal attorney for that?
Probably happy.
Because you had a good relationship with him?
Yes, sir.
And did you continue to work with Mr. Kasowitz in his representation of President Trump in connection with the Mueller investigation?
Not that I recall.
So you were aware that Mr. Kasowitz was selected. Mr. Kasowitz was representing President Trump, and you weren't really a part of that, right?
No, I was not.
But you were still special counsel, personal counsel to President Trump, correct?
Yes, sir.
You also did a fair amount of legal work for the First Lady in 2017, correct?
I did legal work for the First Lady.
There was an issue with Madame Tussauds, correct?
Yes.
And you helped with that?
I reviewed the agreement, yes.
And reviewing the agreement is helping with that?
Yes, sir.
You also met with the First Lady on many occasions, at least in February and March and April of that year, right?
Yes, sir.
Did you meet with the First Lady in New York?
Yes, sir.
Because she was still in New York at that time?
Yes, sir.
And part of your role in meeting with her was helping her with legal issues or potential legal issues, correct?
No, sir.
Well, was the Madame Tussauds a legal issue? Was there do you recall there being a trademark issue that arose involving Melania during that time period?
Yes, sir.
And did you help with that situation?
I did.
And again, that's legal work you were performing for the First Lady, right?
Yes.
But you separately met with her on multiple occasions for non-legal work as well, right?
Personal matters.
And did you view that as part of your job?
Yes, sir.
So, part of your job had always been, or at least for many years, had been not only doing legal work, but helping President Trump and his family with an array of issues, right?
Correct.
And your job was being President Trump's lawyer, correct?
Yes, sir.
There separately seems to be an indication in the ways that the payments were moved that Cohen was in fact getting paid for his work as personal attorney to the president. The first 3 checks were paid from the Trump Org Trust, which is the entity that controlled the Trump Organization while Trump was president. But then, somebody realized that given that Cohen was the personal attorney to the president, he should be getting paid from Trump's personal expense account. So the rest of the checks were issued from that account. This series of events is more consistent with Cohen being paid for services rendered than it being a payment that is trying to be hidden somewhere in the Trump Organization. If the $420,000 was a payment to Cohen for work that he was doing and it was unrelated to any repayments, then the entries on the business documents are now true. There is no crime and Trump must be found not guilty. Even if one doesn't believe that Cohen did any work for Trump at all in 2017, that doesn't actually matter. When you have a retainer agreement with a lawyer, you have to pay them, even if no work comes up. In fact, Cohen was paid $1.2 million by a Swiss medical company for a retainer for which he did no work and only met with them 6 times total. Now, there was no written retainer agreement, and the court did not explicitly outline what the law counts as a binding retainer agreement in New York, but the defense did manage to get Keith Davidson to talk about the agreements he has with his clients.
And so you served as a conduit to help get this story down?
I was asked. I was in essence retained to use my best efforts to get that blog taken down, yes.
And you said, in essence, retained. You were, in fact, retained by Stormy Daniels in connection with that engagement, right?
Yes.
And that engagement, the attorney-client engagement, was not committed to writing, was it?
It was not.
And there's nothing wrong with that, is there?
There is not.
That's an ethical practice to have an attorney-client relationship without an engagement letter, right?
Yes.
And you also worked to have the Daily News take down their internet article reflecting Ms. Daniels' allegations, correct?
I believe so.
And in connection with that effort, you working to get the story from the Daily News down, you were also acting as Ms. Daniels' attorney, right?
Yes.
Still no retainer agreement, right?
Correct.
Did you ever have an engagement letter with Ms. Daniels?
Yes.
Was that in 2016?
Yes.
Cohen was also questioned on his past retainers.
And you never had a retainer agreement with any of those individuals, did you?
No, sir.
And the reason why you didn't have a retainer agreement is because you didn't need one, right?
Correct.
And you didn't need one because you were employed by the Trump Organization, correct?
That's correct.
And so you knew you were going to get paid, right?
Yes.
And there were some parts of your salary you didn't know that would be bonus? You knew your salary?
Yes, sir.
So you didn't have to worry when you did personal work for Donald Trump Jr. about a retainer agreement because you were getting paid by the Trump Organization, correct?
Correct.
Now, you testified multiple times on Tuesday that when you were President Trump's personal attorney in 2017, you had no retainer agreement, right?
Correct.
But the truthful testimony is that in the whole time you worked for the Trump Organization, you never had a retainer agreement, correct?
I never had a retainer agreement.
So it's not just January 2017 that you did not have a retainer agreement. It is from the day you never went back to your law firm, and the Trump Organization sent some guys over and packed up your bags, and you started working for Donald J. Trump, and you never had a retainer agreement, right?
No, sir.
Is there anything wrong in your view? You were a lawyer, right?
Yes, sir.
You were acting as a lawyer the whole time you worked for the Trump Organization?
Well, I did legal matters and non-legal matters.
Understood. But you did legal matters?
Yeah.
And ethically, there was nothing wrong, correct?
I was an employee of the Trump Organization, nothing unethical.
Right. So when you were an employee, you had a job with the Trump Organization, right?
Yes, sir.
And your job was to report directly to President Trump, right?
To whatever Mr. Trump wanted me to do.
You were an executive vice president, right?
Right, yes, sir.
And if that direction included doing legal work for Melania Trump, for example, you did it, right?
Yes, sir.
And ethically, nothing wrong with that, correct?
Correct.
Because you know under New York ethics rules, you don't need a retainer agreement to do work for a client, do you?
No, sir.
We can also see in an email after Cohen became the personal attorney to the president that Alan Weisselberg asked him to set up an agreement they'd discussed. That certainly would be a strong indication that they discussed a retainer and had a verbal retainer agreement. So, if there was an oral retainer agreement and it was valid and Cohen was paid according to that, then there are no false business records, no crime, and Trump is not guilty. If the inaccuracy of the business records are shaky and looking at the evidence from both sides, it was not proven beyond a reasonable doubt, then Trump must be found not guilty. This wall is an example of the defense putting forward their own theory of events and arguing that the evidence fits it better. But they don't actually need to do that. They just need to raise a reasonable doubt in the story put forward by the prosecution. And a great way of doing this is by showing witnesses to be non-credible. Michael Cohen is all over this case, and if he is believed, that alone is nearly enough to find Trump guilty. So it is vital for the defense to show that Cohen is wrong or lying. He was on the stand being cross-examined for multiple days. Let's see if and how the defense discredited him. We just saw on wall 1 an example where we could compare what he said to the prosecution about the amount of work done in 2017 and what he admitted to the defense afterwards. These two were certainly contradictory, but Cohen was caught out some other times too. Here is how Cohen described the magnitude of his payment to Daniels on direct examination.
At some point, did you have a conversation with Mr. Trump about the fact that you were willing to pay for it, at least initially?
Yes, Alan and I spoke to Mr. Trump. We expressed to him that I was going to front the money for it, to which he was appreciative and good.
Did you have a sense from Mr. Trump that you would end up being out the money or you would get paid back?
He stated about it. Don't worry about it. You will get the money back.
Would you have ever paid for the NDA for Stormy Daniels on your own without an understanding that you would get paid back?
No.
Why not?
It's $130,000. I was doing everything that I could and more in order to protect my boss, which was something I had done for a long time. But I would not lay out $130,000 for an NDA needed by somebody else.
So, it's quite a substantial amount of money. Cohen would not have paid it without being assured he would be reimbursed. However, a year later, Keith Davidson calls Cohen, and Cohen himself decides to record the phone call. Davidson is calling Cohen to tell him that the bank is questioning him about the wire that he received from Cohen's shell company, Essential Consultants.
I just thought,
That's just so
honestly,
interesting because the amount was just not really that significant.
Correct. Yeah, it was. I can look it up, but it was 100, 120 or something.
No, I
like
think it was like 135 or something like that.
that. Yeah.
So it seems like the payment is not that big in the view of Cohen and Davidson, who are both well-paid lawyers. Cohen did take the money out of a home equity line of credit, but he admitted that this was just to hide the payment from his wife and not because he actually needed a loan. It's worth keeping in mind that at least at the time of the payment, Cohen was very wealthy. In the 5 years preceding the payment, he made $375,000 in base salary and got a $150,000 bonus each year. He also made millions from taxi medallions, which he owned. In 2018, he had to pay restitution for unpaid tax between 2012 and 2016, which summed to $1.394 million. So that $130,000 payment was just 10% of what he was underpaying in taxes. The payment was not very substantial for him. The defense say that Cohen is bigging up the size and importance of the investment and is lying on the stand. Cohen testified on direct that he recalls a call in October where he updates Trump on the Stormy Daniels deal and tells Trump that he would fund it himself. This is a strong piece of evidence. It points directly towards Trump's knowledge and involvement. The only problem is that the defense found something in the call logs to dispute this story.
Do you recall testifying in response to conversations from the prosecutor about the phone call you had with Mr. Schiller at 8:02 p.m. on the 24th, 2 days earlier? Do you recall testifying about that?
Yes, sir.
You recall saying that you called Mr. Schiller on that evening because you wanted to speak to then Mr. Trump, right?
Correct.
You wanted to speak to President Trump to discuss the Stormy Daniels matter and the resolution of it. That was your testimony, right?
That was...
Then you testified just a couple of days ago that you were successful. You called Mr. Schiller and you had a conversation. And in that conversation, you resolved you were moving forward to fund the deal, correct?
Correct.
Can you explain to us how that works? You know that Mr. Schiller is with President Trump, and so you know that you can call his phone and that Mr. Schiller just hands President Trump the phone?
Yes, sir.
Can you tell from your conversation with President Trump whether he was on speaker or whether you were just talking to him?
I didn't take notes.
So you don't recall either way?
No, sir.
But you recall that on that call, I don't want to put words in your mouth, you discussed the Stormy Daniels matter and the resolution, and you also discussed the conversation would be that it was resolved, that you were going to move forward and fund the deal, right?
Yes, sir.
That was your testimony?
Yes, sir.
Do you remember? I appreciate this goes back a while. Do you remember at that time, October 22nd, 23rd, 24th, 2016, you were receiving a bunch of ongoing and continuing harassment phone calls? So somebody was calling you constantly. Do you remember that?
Yes, sir.
And do you remember that on the 24th, at around 7 o'clock at night, the person who was harassing you forgot to block the number, and you got the number? Do you remember that?
No, sir.
Let me show you what has been marked for identification, just for you, the court, and the B-165. Do you see your text to this number that says, "This number has been sent to Secret Service for your ongoing and continuous harassment to both myself as well as to the organizations named on it"?
I do.
That is at 7:10 p.m., right?
Yes.
And then the text back says, "It wasn't me. My friend told me to call. I am sorry for this. I won't do it again," right?
Yes, sir.
Then you respond and said, They're going to have to explain that to the Secret Service, because you have been receiving dozens of these harassing calls over the past 3 days, right?
Correct.
If you are a minor, I suggest you notify your parent or guardian. That's what you said to them, right?
I did.
The person texted you back and said, I didn't do it. I am 14. Please don't do this. You eventually said to have their parent or guardian contact you.
When they expressed they were 14, I felt it was proper.
That was at 7:24 p.m. on that same date, October 24th, right?
I am sorry. What time?
The last text was at 7:24 p.m.?
Correct.
So that whole exchange was between around 7:10 and 7:24 p.m.?
Correct.
That was an exchange because you had been receiving a bunch of harassing phone calls the prior 3 days?
Correct.
Do you recall at 7:48 texting Keith Schiller about this 14-year-old? Do you recall that? Do you recall that?
I don't recall.
Do you recall texting Keith Schiller at 7:48 p.m.? Who can I speak to regarding harassing calls to myself in office? The dope forgot to block his call on one of them. You don't? Do you recall at 8:02, your initial text to Mr. Schiller is at 7:48, and then at 8:02 he says, call me, to you, right?
Yes, sir.
If you can highlight the 10/24ths, the 8:01 and 8:02 calls, that shows a voicemail at 8:01 from Keith Schiller to you?
Yes, sir.
And then at 8:02 he says, call me. And then it looks like you then call him at 8:02 for 1 minute and 36 seconds, right?
Correct.
This is the call that you testified about on Tuesday, that you had a conversation with President Trump, that you called Keith Schiller. It wasn't to talk to Keith Schiller, it was to talk to President Trump about the Stormy deal and the moving forward. That was your testimony.
Yes, sir.
You call him back at 8:02 for 1 minute and 36 seconds. At 8:04, you text him the number of the 14-year-old who was prank calling you, correct?
I did, yes.
Immediately he texts you back within a few seconds. He said, okay?
Yes, sir.
The very next morning at 7:58 a.m., you say, did you reach the family, right?
Yes, sir.
When you testified on Tuesday that you had a specific recollection that 1 minute and 36 minute phone call on October 24th was not with Keith Schiller, that you called Keith Schiller and he passed the phone to President Trump, you finalized the deal with Stormy Daniels and you said, we're going to move forward. And he said yes, because you kept him informed all the time. That was your testimony, right?
That's correct.
That was a lie. You were actually talking to Mr. Schiller about the fact that you were getting harassing phone calls from a 14-year-old, correct?
Part of it was the 14-year-old, but I know that Keith was with Mr. Trump at the time, and there was more than potentially just this. That's what I recall based upon the documents that I reviewed.
5 minutes ago, I asked you if you remember harassing phone calls, and you said no. And then I refreshed your recollection. It's totally fair if you don't remember. But now your testimony is that you were testifying truthfully on Tuesday to a 1 minute and 36 second phone call, and you had enough time in that 1 minute and 36 seconds to update Mr. Schiller about all the problems you were having with these harassing phone calls, and also update President Trump on the status of the Stormy Daniels situation, because you had to keep him informed, because every time you made any decision, you ran it by the boss. That's your testimony?
I always ran everything by the boss immediately, and in this case, it could have just been saying everything is being taken care of. It's going to get resolved.
That's not what you testified to on Tuesday. You said you had a recollection of a phone call on October 24th at 8:02 p.m. where you called Mr. Schiller and he gave the phone to President Trump, and you told President Trump about the updates, that you were moving forward with the funding, and he said, okay, go. That was a lie. You did not talk to President Trump on that night. You talked to Keith Schiller about what we just went through. You can admit it?
No, sir, I can't. I'm not certain that is accurate.
You were certain it was accurate on Tuesday when you were under oath and testifying. You were certain it was accurate you had a phone call to President Trump. But now you are saying you are not certain it was accurate.
Based upon the records that I was able to review, in light of everything that was going on, I believe I also spoke to Mr. President Trump and told him everything regarding the Stormy Daniels matter was being worked on, and it's going to be resolved.
If Cohen is indeed lying about that, how can we trust anything else he says about Trump's involvement? Cohen also testified that he did not want to work in the White House, but he would have liked to be offered a role which he would then turn down. He felt that he deserved this, given his contribution to Trump's campaign. The defense think that he actually wanted the role, and feel slighted that he didn't get one.
Do you remember telling Congress that it was a lie, that you did not want to go to the White House? Do you remember saying that to Congress?
I remember telling Congress I did not want to work in the White House.
Well, do you remember saying what you testified to on Tuesday is that you didn't want to go to the White House?
Yes.
And that you wanted to continue in the role as President Trump's personal attorney, right?
Yes, sir.
And that you were offered jobs in the White House, right?
I was offered a role, yes.
You also testified that you were present when President Trump reamed out Mr. Priebus because you hadn't taken a job that you were offered, right? And that job was a job we talked about a minute ago in the White House counsel's office?
Correct.
But the truth is, Mr. Cohen, you really wanted to work in the White House, correct?
No, sir.
You didn't simply indulge friends and family about working in the White House like you testified about. You really wanted to work in the White House, correct?
Again, no, sir.
You hoped that you would be named the White House Chief of Staff. Not just be considered, but be named the White House Chief of Staff, correct?
No, sir.
Are you familiar with somebody named Spencer Zwick?
Yes, sir. I know Spencer Zwick.
Who is that?
He was the fundraiser for Mitt Romney.
And was that when Mr. Romney was running for president?
Yes, sir.
Do you recall having a conversation with Mr. Zwick where he asked you whether you wanted to be Attorney General Cohen or Chief of Staff, and you answered Chief? Do you recall that?
Yes, sir.
And that was still during the campaign, correct?
Correct.
And then after President Trump was elected in November, he congratulated you and he said Chief of Staff. And you said that would be nice, correct?
Correct.
Are you familiar with somebody named Rita Vaigman?
Yes, sir.
Who is that?
It's a friend, family friend.
She is a fashion executive in New York?
Yes, sir. Actually, Florida, but yes, she relocated.
And do you recall on November 9th, so right after the election, you told her that she was going to come to the White House with you to be your assistant to the Chief of Staff. Do you remember saying that?
Yes.
And then a few days later, November 12th, so still November 2016, you had a series of communications with a family member, with your daughter, where you discussed whether you still had a chance at the Chief of Staff position, right?
Amongst other texts, yes.
And your daughter actually alerted you to the fact that she read that there was a consideration that Mr. Priebus would be Chief of Staff. And you said he is pushing like a madman, right?
Yes, sir.
And then there was a continued conversation about whether you still had a chance to be Chief of Staff. And you said there was still many opportunities, right?
Yes, I think I also used the word hybrid.
The defense also tried to show that he was lying about not wanting other roles in Trump's administration, but they were much less effective than this example. So, we have a number of times that the defense have pointed to Cohen lying on the stand, which can put his entire testimony in question. But they also have a theory as to how and why he did it. At this point, Michael Cohen doesn't like Trump, and he has a podcast where he often talks about Trump in a negative light. He makes money from publicly discussing Trump, he makes money from his podcast, and also sells merchandise on his website, which is, let's say, not particularly complimentary of Trump. He released a t-shirt to celebrate Trump's indictment and arrest, and also merchandise supporting Biden, labeling Trump a fascist, and supporting sending him to jail. The 45 on the merch refers to Trump, by the way. He was the 45th president. But even if Cohen hates Trump and is willing to lie on the stand to help find him guilty, how did he pull it off? There were some discrepancies in his testimony, but for the most part, the story matched what others were saying. Well, for this, we have to look at the trial schedule, and we can see that he was one of the last to testify, so Cohen could have kept up with the prior testimony of others and molded his story to fit with what they have said. Obviously, that's just a defense theory. I mean, unless Cohen admits to following the trial before testifying. Hey, what's this?
Mr. Cohen, you have been following what's happening in this trial, correct?
To some extent, yes.
Well, you know, for example, details around the jury selection process, correct?
I have made comments about the jury selection.
Now, on April 23rd of this year, so after the trial started, you said that you had actually heard what a witness had testified about, correct?
Objection, Your Honor.
Overruled, you can answer.
It's possible, yet.
Well, do you recall testifying? Do you recall saying on TikTok on April 23rd, and that's when Mr. Pecker was still on the stand, that from everything that you heard from people today, David Pecker is corroborating what you have been saying for 6 years. Do you recall saying that?
I do, yes.
And that's because you heard from people about what Mr. Pecker had testified to in this trial, correct?
Yes, somebody had called me and told me that Mr. Pecker had corroborated what I have been saying for a long time.
And it's true that you also have been following what's happening in this courtroom on CNN and MSNBC, correct?
I have seen CNN and MSNBC, but I'm not following the trial.
Well, Mr. Cohen, you have been watching CNN and MSNBC during this trial, correct?
I have been on CNN and I have watched CNN and MSNBC, but not religiously, in order to follow the full extent of the trial.
And you have said that you are watching on CNN and MSNBC, maybe not all the time, about some of the things that are happening during this trial, correct?
I've turned it on, yes.
And that's because this trial is important to you, correct?
I do it because at times there are other issues as well that I'm interested in seeing what's happening, like the protests or Israel, and this issue comes up as well.
Well, is this trial important to you, Mr. Cohen?
Personally, yes.
So the defense claim that Cohen is fabricating his testimony. They say that Cohen can't be trusted because even according to him, he's an admitted liar. He lied to his wife about the Daniels payment. He lied to his bankers to set up the shell companies for the hush money settlement. He lied to the FEC, prosecutors, and reporters for about a year when he was trying to cover up the payment. And he is a convicted felon, guilty of lying to the Congress and lying to the Senate. He's also a self-professed thief. Cohen says that he was reimbursed for the Stormy Daniels payment and for some money he put forward to Red Finch. They had done some consulting work for Trump, and Trump had refused to pay them. Cohen was friends with the CEO, so he settled the matter by paying the CEO a smaller amount than the full $50,000. Then, in 2017, he got paid back for the full amount by Trump, pocketing the difference. Cohen says he did this since he didn't think that Trump deserved the discount that he had negotiated with Red Finch. This is basically theft. The defense say that Cohen is a liar and a thief and that he lied on the stand. But there's another reason that Cohen's evidence is weak. Cohen is a co-conspirator in creating false business documents, and he has spent time in jail for falsifying documents related to this case. According to New York law, you can't use just the testimony of a co-conspirator to find someone guilty of conspiracy. That means that even if you believe everything that Cohen says, unless it is corroborated by other evidence, you can't use Cohen's statements alone to find Trump guilty. If the defense have shown that Cohen is unreliable, then the jury should just disregard his testimony completely. The prosecution also put forward evidence that Trump acted with others in the Trump Organization to create false business documents. They have to prove this beyond a reasonable doubt. However, when we analyze these 34 documents, we can see there are some weaknesses in this theory. There are 11 invoices which were emailed from Michael Cohen to Alan Weisselberg at the Trump Organization. They weren't sent to Trump. Trump didn't see them pop up in his inbox. There is no reason at all that Trump would have seen the emails. The prosecution did provide evidence from Deborah Tarasoff and Rebecca Minocchio that it was practice in the Trump Organization to staple the invoices to the checks. The signer would then read the invoices and sign the checks. However, Tarasoff didn't say that she had a specific recollection of preparing the 11 checks in question this way. So there was no direct testimony in the trial that Trump ever even saw the invoices. There are also 12 vouchers which were created by Deborah Tarasoff in the MDS system. Tarasoff would have seen them, McConney would have seen them, other accountants at the Trump Organization would have seen them, but there is no reason at all that Trump would have seen them. In fact, there was not a single piece of evidence in the whole trial that showed that Trump knew the MDS system even existed, let alone that he knew about the 12 vouchers that he's charged for. Finally, we have the checks. Trump didn't sign the first two, and there is no evidence that he knew that Allen Weisselberg and Donald Trump Jr. signed them. For the checks he did sign, it really comes down to whether he was paying meticulous attention when he was signing them, or if he was just signing them carelessly. We have already heard testimony from Pecker that Trump would sign checks while having a separate conversation with him. This would obviously limit the amount of attention Trump could put towards analysing the checks. Pecker's recollection was from Trump Tower, and one would imagine that when Trump was president, he had even less time to sign checks, which makes it more probable that these 9 checks were signed while Trump was multitasking. Madeleine Westerhout worked in the White House with Trump, and she shared her recollections of Trump signing checks.
And with respect to the checks, they came in a folder, am I correct?
Yes.
And if he had the time when you gave them to him, he would sign them?
Yes. If he had the time and if he was in the office, yes.
And you said he signed a tremendous amount of items, right?
Yes.
And there were proclamations that he was signing?
Yes, commissions, proclamations, executive orders, memos, letters.
And that would take up many hours of his day, right?
Yes.
Because he did not like to have that in printed form, right?
No.
And were there times, with all these, would you say it was hundreds of documents that he was signing?
Not every day, but sometimes,
And this was in between other things that he was doing, right?
Oh, yes,
And so, would you see him signing things without reviewing them?
Yes.
And would you see him signing checks without reviewing them?
Yes.
And you would see him signing checks while he was on the phone, right?
Yes.
Would you see him signing checks when he was meeting with people?
Yes.
And there were different types of people that he was meeting with, right?
Yes.
Sometimes he was meeting with the top foreign leaders in the world, right?
Yes,
And other times he was meeting with you.
Yeah,
And so he wouldn't be signing the checks when he was meeting with the top people in the world?
Yes.
But maybe when he was meeting with you, talking about something else, he would also be signing documents?
Yes. Talking about the schedule or anything that had been going on.
The chief of staff that he would be meeting with?
Yes.
And other people he would be doing that?
That's right.
He was a person who multitasked, right?
Definitely.
The prosecution couldn't prove that Trump knew about the invoices, the vouchers, and the first 2 checks. And they couldn't show that he didn't just mindlessly sign the last 9 checks. All of that is reasonable doubt. The prosecution had to prove beyond a reasonable doubt that Trump acted with others in the Trump Organization to create the 34 documents. They couldn't even prove that he knew any of them existed. This wall of Trump's guilt is incredibly weak, and it cannot support a finding of guilt. Now, when it comes to the conspiracy to influence the election, the prosecution put forward evidence showing that there was a conspiracy and that there was at least one illegal means. But the defense say that there was no illegal conspiracy. There is nothing wrong with conspiring to influence elections. That's all that campaigns do. They work as a group to influence elections. The prosecution made a huge show out of all the different elements of Trump, Cohen, and Pecker's plan. But this was just business as usual for AMI. And if we compare what they did for Trump to what they did for other politicians and celebrities, we see that Trump didn't get any special treatment. The prosecution made a huge stink about positive stories about Trump and negative stories about Trump's opponents, which were published in the National Enquirer. They said it was part of a conspiracy. However, On cross-examination, Pecker explained exactly why the positive stories were published.
And there was a bit of a science to the way that you were running AMI and the National Enquirer in this time frame, right?
Yes.
This time frame being 2016 and a lead up to the election, correct?
That's correct.
You had researchers who calculated and assigned a score or a rating for potential stories, right?
Yes.
And the purpose of having them do the research was to figure out how to maximize profit for AMI, right?
Yes.
Getting back to the fiduciary duty that we talked about.
Yes.
You actually participated in those meetings, correct?
Yes.
In quantitative assessment of how AMI was going to make money based on stories was something that you were personally involved in?
Yes, I was.
And focused on?
Yes.
And I think you said on Tuesday that by that time, The Celebrity Apprentice, the research showed that President Trump was the top celebrity in terms of helping sell the National Enquirer?
Absolutely.
And so that's The Celebrity Apprentice that we are talking about in the early 2000s, correct?
Yes.
And that was already established in your mind that President Trump was one of the people who could drive the most sales and maximize the most profit for the National Enquirer, right?
Yes.
And so you ran articles about President Trump because it was good for business, correct?
It was good for business.
Pecker also outlined the business reasons for the negative stories about Trump's opponents.
And 3 specific opponents, preliminary opponents, came up, right?
Yes.
Ben Carson, correct?
Yes.
Marco Rubio, right?
Right.
And Ted Cruz, correct?
Yes.
And you were shown some exhibits by the government that related to stories the National Enquirer ran about those 3 men, correct?
That's correct.
There wasn't much new content in those stories, was there?
I would have to reread the stories to answer that question.
We'll take a look at the stories in a minute. But let me ask you this. It was standard operating procedure for the National Enquirer to sort of recycle content from other publications and frame it slightly differently, correct?
Correct.
That's cost effective?
Correct.
Information from the public domain goes into the National Enquirer. It's quick and easy, correct?
Yes.
Good for business?
Yes.
Consistent with your fiduciary obligations, correct?
Yes.
And for at least some of the articles that you testified about on Tuesday, that's exactly what you did, right?
Yes.
There was already negative information in the public domain about Ben Carson, and so you ran it in the National Enquirer, right?
Yes.
And because that was quick and efficient and cost-effective, you would have done that whether or not you had discussed it with President Trump, correct?
Yes.
So you see that there's an article, the top article on this page relates to some kind of issue with a surgery performed by Dr. Carson, right?
Yes.
And in this time frame, 2015, you were leading AMI, right?
Yes.
And you were familiar with what was going on with other publications, correct?
Yes.
You had to be, right, in order to do your job?
Yes.
And you had to be on top of what was in the public domain at the time, correct?
Yes.
You had to keep track of current events, right?
Yes.
So you knew, did you not, that in May 2015, The Guardian published an article regarding several malpractice suits against Dr. Carson, correct?
That's correct.
And so in May 2015, long before any of the articles on this page, The Guardian had covered this issue, right?
Yes.
And in fact, the Guardian article referenced 7 malpractice claims against Dr. Carson, right?
Yes.
That photograph on the top of a child is actually recycled from the Guardian article, correct?
Yes.
And so there are 4 articles on this page that relate to these medical malpractice claims, correct?
Yes.
And all of them contain information that was recycled from a publication months earlier in The Guardian, right?
That's correct.
You see the 4th headline on this page?
Yes.
There's a reference to military service?
Yes.
And do you recall this is also a situation where the National Enquirer posted information that was already in the public domain? Do you recall 5 days earlier, Politico ran a headline, exclusive, Carson claimed West Point scholarship but never applied?
Yes.
And these articles are also based on information that was not exclusive to the National Enquirer, correct?
Yes.
The top article actually refers to a book that had been published about Mr. Rubio, correct?
Correct.
So it wasn't new information published, correct?
That's correct.
Substantially, everything in the exhibits you were shown in 153A, 153B, and 153C, what was going on was the National Enquirer was recycling information from other publications because it was cost effective and made business sense,
Objection. Overruled. You can answer.
Yes.
They ran positive stories about Trump since that was popular with their readers, and the negative stories were mostly just recycling from other news organizations. The prosecution claim that there's a problem with Trump working with AMI to protect his image and help his campaign. But this is something that Trump had done with AMI long before he was running for president.
Now, 1998 was one of the first times that you gave President Trump a heads up about a potentially negative story, correct?
Yes.
Just before you took over at the National Enquirer?
Yes.
And this was a story relating to Marla Maples, right?
Yes.
And you tried to stop the story from running, correct?
Yes.
And you tried but failed?
Yes.
It ran?
Yes.
But this was the first time that you made that effort to reach out to President Trump about a story and to prevent it?
Yes.
And that's almost 17 years prior to the meeting that you described in August of 2015, right?
That's correct.
So 17 years of providing President Trump with a heads up about potentially negative publicity, correct?
That's correct.
Fair to say that predated that meeting at Trump Tower in August 2015 by a long time?
Yes.
It was a lot of interactions, correct?
Yes.
And several stories, right?
Yes.
In addition to Trump Style, you also used the National Enquirer to run positive stories about President Trump, right?
Yes, I did.
Again, long before 2015, correct?
Yes.
And because that was good for business, right?
Yes.
And this sort of took off, this idea of using the National Enquirer to promote President Trump because it was good for you around the time of The Apprentice, the first show?
That's correct.
And this is in the early 2000s, correct?
Yes.
And I think you said on Tuesday by that time, early, you and President Trump had a mutually beneficial relationship, correct?
That is correct.
In addition to a friendship?
Yes.
And on the mutually beneficial relationship side of things, President Trump was giving you content to run in the National Enquirer, correct?
Yes.
And that included information about ratings relating to The Apprentice?
That's correct.
And what was going on with the show?
Yes.
Access to participants on The Apprentice, right?
Yes.
And that helped you, correct?
Yes, it did.
And in exchange for that, as part of this friendship, you also continued to provide President Trump with information about potentially negative stories?
Yes.
And you also promoted some of President Trump's positive stories, correct?
I did.
Before this investigation started, you had not heard the phrase catch and kill, correct?
That's correct.
Never heard of it?
That's right.
The first time you heard that phrase was from a prosecutor, right?
That's correct.
This relationship that you had with President Trump, this mutually beneficial relationship, you had similar relationships with other people, right?
I did.
Meaning that there were other people for which you would provide a heads up if there was a potentially negative story, correct?
Yes.
And other people that you would promote in the National Enquirer because it was good for you and it was good for them, right?
Yes.
And that included celebrities, right?
Yes.
And most celebrities want positive treatment in all publications, right?
They do.
And you also had relationships like this with other politicians, correct?
Yes.
And you are aware that many politicians worked with the media to try and promote their image, right?
Yes.
And to promote their brand, correct?
Yes.
To facilitate their campaigns, correct?
Yes.
Standard operating procedure as you understand it.
Yes.
And then sometimes when the politicians are doing that, that is to try and win elections, right?
Yes.
Nothing surprising about that, is there?
No.
And that's your personal experience, correct?
Yes.
And you are also aware from your decades of experience, right?
Yes.
That includes even presidential candidates, correct?
Yes.
Long before 2016, right?
That's correct.
Cohen had also worked on Trump's behalf with Pecker to protect Trump's image long before the supposed conspiracy.
President Trump introduced you to Michael Cohen around 2007, I think you said?
Yes.
And at that time, President Trump told you that Cohen was his personal lawyer, right?
That's correct.
And that's the only job that you knew Cohen was doing for President Trump, right? Personal lawyer?
Yes.
He became sort of an intermediary to help you provide information to President Trump about potentially negative stories, right?
Yes.
And also when there were situations where President Trump could be promoted in the National Enquirer, right?
Yes.
You started to work with President Trump's personal attorney, Michael Cohen, on those issues, correct?
Yes.
For at least 8 years prior to the August 2015 meeting, right?
Yes.
And in 2015 and 2016, Cohen was always clear with you that he was not working for the campaign, correct?
Yes.
All of this is very important because one of the sets of illegal means of the conspiracy that the prosecution put forward is a violation of election law through large in-kind donations. One defense against this is to show that the in-kind donations would have happened even if the candidate wasn't running for office. So, before Trump ran for president, AMI published positive stories about him and alerted him about any negative stories in the marketplace. And after he started running, they continued doing the exact same thing. However, now it is supposedly a conspiracy and illegal. There were also other examples of politicians who had worked with AMI to help their campaigns. In fact, when Arnold Schwarzenegger was running for the governor of California, AMI did even more to help him than they did Trump.
And you testified today about having done something similar for Arnold Schwarzenegger, correct?
I did.
Around the time that he was running for the governor of California, right?
Yes.
That was in 2003?
Yes.
And in that period, were you trying to acquire AMI's holding into the fitness phase, right?
I did.
And I think you mentioned some of the publications Shape, Muscle and Fitness, Men's Fitness, Flex, correct?
That's correct.
And as you tried to make those acquisitions, it was a huge deal, right?
Yes.
Worth about $365 million?
That's correct.
And so you wanted this to go through very much, correct?
I did.
And I think you said it this morning that you talked about it with Joe Weider?
Yes, I did.
Who was sort of a celebrity in the fitness phase and owned some of these publications?
Yes.
And Mr. Weider said, I'm interested, but we need Arnold's blessing, correct?
Yes.
And in order to move forward with this, would you a giant acquisition, $365 million?
Yes.
To move forward with this giant acquisition, you needed Arnold's blessing, correct?
Yes.
And so you went and met Arnold personally?
I did.
And you reached an agreement?
Yes, we did.
And there were a few aspects to this agreement, is that correct at the time, right?
Yes.
And at the time of this agreement, he had not yet announced his candidacy to become the governor of California, right?
That's correct.
And so one aspect of the agreement was that Mr. Schwarzenegger did not want any more negative stories written about him in your magazines, right?
Yes.
And I think you said this morning that he had expressed some concerns with you that in the past, the National Enquirer had run some pieces that he didn't like.
Yes.
And you agreed, did you not, to make that happen? To stop running negative stories about Arnold Schwarzenegger?
I did.
And Mr. Schwarzenegger also asked for help because he thought that there were a number of women that were going to come out and make accusations once he announced his campaign. Is that correct?
Yes.
And you agreed to help him with that, correct?
I did.
And in addition to that, Mr. Schwarzenegger, we given equity in AMI, correct?
Yes.
How much equity was he given in AMI in 2003?
I remember it was less than 10%.
How much was that worth at the time?
It was probably worth at the time around $50 million.
So $50 million in equity on a $365 million acquisition, right?
Well, it was equity of the whole company.
It's a significant amount relative to the size of the deal.
Yes.
And Mr. Schwarzenegger was also given executive positions, executive titles at least, in AMI's affiliates, right?
Yes.
And then he announced his candidacy, correct?
Yes.
And I think you've said before that at that time, women started coming out of the woodwork, right?
That's correct.
And so this morning you mentioned one story that you purchased for Arnold Schwarzenegger, correct?
Yes.
Purchased in 2003, right?
Yes.
But in fact, 30 or 40 women came to you and AMI was following that. The announcement of his candidacy, correct?
Yes.
And you spent almost $1 million purchasing the rights to those stories, correct?
I didn't think it was that high.
Several $100,000?
It was hundreds of thousands of dollars.
And Mr. Schwarzenegger never paid you back for that, correct?
No, he did not.
Now, I think that the one story that you described purchasing this morning, was it the source of that? Was Gigi Goyette?
Yes.
And you bought the rights to a book that she wanted to publish about her relationship with Mr. Schwarzenegger, correct?
That's correct.
And you actually, during the candidacy, sent reporters to Ms. Goyette to bring her to Hawaii to get her away from California so that Mr. Schwarzenegger could campaigns, correct?
I did.
And at some point there was some backlash over this, correct?
Yes.
And that happened when you were investigated about an FEC's disclosure relating to the equity interest granted to Mr. Schwarzenegger, right?
That's correct.
And I think you testified this morning that there was an investigation in California?
Yes.
There were no findings against AMI in connection with that investigation, correct?
No.
And as a result, there was also an internal investigation at AMI, correct?
Yes.
And I don't want to get into what you said to your attorneys or not, but as a result of that investigation, you and AMI decided to implement new policies and procedures around this type of issue with assisting a campaign like Mr. Schwarzenegger's, right?
Yes.
And you did that, right? You implemented policies and procedures?
We did.
And you followed them, correct?
I did.
Followed them, including in connection with the events you described in 2015, 2016, and 2017, correct?
I thought I did.
You thought you did?
Yes.
Pecker also didn't just catch and kill stories for campaigns. He testified about buying stories for other celebrities too.
You have also purchased a story relating to Tiger Woods, right?
We didn't purchase, I should say yes, it was a source agreement, so we did purchase it, yes.
And you purchased some photographs, right?
We purchased a story about Tiger Woods from a source, but all the investigating photographs, all the investigative works was done internally.
And the photographs that we're talking about are photographs of a woman meeting with Tiger Woods at a parking lot in Florida, right?
That's correct.
And this is one of those instances where you bought the rights to a story in order to leverage it against a celebrity, correct?
Yes.
To use the access that you had to this information and the exclusive rights that you had to get Tiger Woods to do something that you wanted?
Yes.
And in this instance, and this is around 2007, correct?
That's correct.
And in that instance, what you wanted was for Mr. Woods to appear on the cover of Men's Health, right?
It was Men's Fitness.
Thank you, Men's Fitness, and you also wanted him to do an interview, correct?
Yes.
And at the time, Mr. Woods, if not locked up exclusively, he had a relationship with Condé Nast, right?
The answer is yes. And he also had an exclusive with, I think it was Golf Illustrated.
So he needed some convincing to sit down with AMI, right?
Yes.
And so you bought the rights to these photographs, correct?
Yes.
And at the time that you bought the photographs, you had no intention of running the story, correct?
No, I wasn't going to run it. The purpose of buying the story...
Oh, I'm sorry, excuse me. The purpose of buying the photographs was to leverage them against Tiger Woods to get him in the magazine, right?
Yes.
So there was nothing unusual about AMI's relationship with Trump. They treated him exactly like any other celebrity that was helping them sell copies of the National Enquirer. The idea of a conspiracy gets more ridiculous when we look at the case of Doorman Dino Sajudin. AMI bought Sajudin's story of Trump fathering an illegitimate child with a maid. They investigated it internally and found that it was false. The deal that AMI arranged was completely standard and identical to any other contract they would negotiate with any other source. It wasn't until much later that Pecker amended this deal to be in perpetuity. This was because Dino was threatening to go to AMI's competitors, and at the time, Pecker thought the story might still be true. On cross-examination, the defense even got Pecker to admit something, which completely destroys the catch and kill narrative.
And you believe that if this story was true, it was worth a lot of money, right?
Yes.
What I'm asking about now is what was in your mind in 2015 as this was happening, okay?
I understand.
So, when it was reported to you that somebody was saying the things that Mr. Sajudin was saying, you believed that if those were true, it could be the biggest National Enquirer article ever?
That is correct.
And I think you testified about the Enquirer's coverage of Elvis Presley's death, right?
Yes.
Think, if I'm recollecting correctly, there were about 6.5 million sales associated with the National Enquirer's coverage of that death.
That is correct.
And you thought that if this story was true, Mr. Sajudin's claim was true, that it could sell 10 million National Enquirers, right?
I did.
So, if this story was true, you were going to run it, correct?
Yes.
Because you had a fiduciary obligation to do that, right?
That is correct.
It would have made business sense, to put it mildly, to run such an article if it was true, correct?
Yes.
And as soon as you heard the story about Mr. Sajudin, you knew that to be the case, right?
I did.
So not really a great conspiracy. Trump, Cohen, and Pecker conspire to catch and kill negative stories about Trump, but the first time a negative story comes up, Pecker would have published it and sold 10 million newspapers. That story, if true, would, if not completely kill Trump's campaign, seriously hurt it. And Pecker would have put it on every newsstand in America. Furthermore, Pecker even literally said that he never discussed a Sajudin deal with Trump, and that Trump never paid him for the Sajudin deal. So even if the deal is illegal, Pecker doesn't connect it to Trump at all. Next, we move on to the McDougal deal. Just like the previous contract, this deal was completely lawful on its face. There is nothing illegal about purchasing someone's life rights. Also, purchasing this story didn't actually influence the election. For the purchase to have made a difference, there would have to have been a different effect if the story wasn't bought by AMI. But that wasn't the case here. Davidson admitted on direct that McDougal wasn't actually looking to publish her story. He also elaborated on this on cross-examination.
Ms. McDougal did not want to publish an article about the claims that have been discussed here, right?
True.
And I think you said on Tuesday that she had 3 goals, right?
Yes.
One goal was to rejuvenate her career, right?
True.
And that was your understanding in 2016, correct?
That's true.
And Ms. McDougal had had a real career up to that point, is that right?
She certainly had had a real career prior to, yes.
She had been on magazine covers, correct?
More than that. Yeah, she had a very healthy career.
And that included not just on the Playboy part, but also in the fitness industry, right?
I believe so.
That directly transitions into the defense's next point. McDougal wanted to get back into the fitness industry, and it worked. As part of the deal, McDougal was put on 2 AMI Fitness magazine covers and wrote 20 articles. According to Cohen, Pecker said that there was no need to pay AMI back for the McDougal deal, since they made so much money from signing McDougal that it was a good business investment. Cohen was under the impression that the men's fitness cover featuring McDougal sold more copies than any previous edition of the magazine. So if the McDougal deal was lawful, and both sides got from the deal what they wanted, McDougal got her career renewed, and AMI sold tons of magazines. And even if the deal hadn't happened, the story would not have been released. Then how could this possibly be a catch and kill deal that influenced the election? Now we get to the planned transfer of McDougal's life rights from AMI to Trump. The biggest thing to deal with here is the tape. The tape supposedly records a conversation between Cohen and Trump. I played it in part 1, and I very intentionally didn't include the transcript that was put forward by the prosecution. This is because the tape is evidence, but the transcript is not. If the jury hears something on the recording which is different from the transcript, they must use their own interpretation, not the prosecution's, when weighing this evidence. On the tape, Cohen is pretty understandable, but Trump is not very clear, to say the least. This is since Cohen was literally holding the phone in front of him when talking to Trump. So I'm going to play it now, and I will be including the prosecution's transcript on screen. So if you don't want to be biased by that, and see what you can hear for yourself, then close your eyes and listen carefully.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and I've spoken to Alan Weisselberg about how to set the whole thing up with funding. Yes, and it's all the stuff because you never know where that company, you never know where he's going to be. Correct. So I'm all over that, and I spoke to Alan about it when it comes time for the financing, which will be.
Listen, what financing?
We'll have to pay you. So
I'll pay for cash.
No. I got no. Hey, Don, how are you?
At the end of the tape, we can hear Cohen saying, "Hey Don, how are ya?" Cohen claims that this was him getting another call from somebody named Kathy Battle, which caused the recording to stop. Putting aside how possible that is, the defense looked through all of Cohen's call logs, and they found that this call went straight to voicemail. Neither side released the full call logs, so I can't independently verify this. But if that's true, it certainly puts in question some of the prosecution's strongest evidence. Even if it went to voicemail, but Cohen thought he picked up the call, we also need to ask why he said "Hi Don" if he was actually getting a call from Kathy. Another factor to keep in mind is that Trump's assistant Rona Graff's voice can be heard earlier on the tape. It is before the key parts that I've played, but Cohen agreed that it was her voice. Miss Graff was actually the second witness at this trial. The prosecution chose not to ask her any questions about the tape. Maybe she could have verified its authenticity, or told us exactly what Trump said. The prosecution intentionally chose not to ask her any questions about that. Finally, we have the Daniels deal. This should be the last nail in the coffin of the conspiracy. That's for one simple reason. Pecker refuses to buy the story. It's a conspiracy to do catch and kills, except Pecker refuses to catch and kill stories. That's not much of a conspiracy. There's also another problem. There was no story to catch and kill. Daniels had published her interaction with Trump in In Touch magazine in 2011. The story was already public. You can't catch and kill a story which is public. So the prosecution say that there was a conspiracy where Cohen, Pecker, and Trump colluded to use the National Enquirer to influence the election. But the National Enquirer writes the same kind of stories about Trump as they did before. They write stories about his opponents, which are low effort and their readership enjoys. The first chance Pecker gets to catch and kill a story, he admits that if it were true, he would have published it and damaged, if not killed, Trump's campaign. They supposedly catch and kill the story, which McDougal wasn't going to publish anyway, coincidentally making a deal with McDougal that sells more editions of Men's Fitness magazine than has ever been sold before. And when Daniels' story comes up for grabs, which, by the way, was already published in 2011, Pecker straight up refuses to buy it. That's not a great conspiracy, if you asked the defense. There's also some other weird details about it that come up, such as that if it is such a super secret conspiracy, when repaying Cohen, why get Eric and Don Jr. to sign the first two checks? Especially since Trump signs the rest of the checks. Why not get him to sign them all from the start? Why include Don and Eric in the cover-up of this super secret conspiracy for no reason? Even if we do believe that there was a conspiracy to write positive stories and catch and kill stories which were harmful to Trump, and that illegal means were used to do it. The prosecution still needs to prove that Trump did it with an intent of influencing the election. Trump doesn't need to be running for president to want good stories about him. If nothing else, it's good business. The Trump brand is so strongly tied to him that positive stories about him make his brand more valuable. So if Trump conspired to have positive stories written to promote his brand, even if he used illegal means to do it, that's not a violation of election law, which is a required part of this case. As for the conspiring to catch and kill stories, these were women and Dino Sejun claiming that he cheated on his wife. You don't have to be running for president to want to cover that up. Trump easily could have conspired to cover up those stories to protect his family. Even if there was a conspiracy and illegal means were used, since Trump was protecting his family and not doing it to help his campaign, he didn't break New York election law. Thus, he's not guilty. The prosecution failed to prove beyond a reasonable doubt that Trump intended to influence the election, and they certainly didn't prove that there was a conspiracy to do it. This wall is weak and Trump is not guilty. The final wall of this case is Trump's intent to have false business documents created. We can take into account evidence from other walls about what Trump said and did, what happened, and what the likely outcome would be based on Trump's actions. That's why we have saved this wall for last, so that we have seen all of the defense's evidence. We can also use prosecution evidence from other walls to prove that Trump didn't have the intent of creating false business records. In fact, some of the prosecution's strongest evidence that Trump knew about the repayment scheme is also the defense's strongest evidence that there was no intent. The prosecution claim that Trump acted with others to create false business records to cover up Cohen getting paid back for buying Daniels' story. If we put ourselves in the mind frame of somebody who is intentionally creating false business documents and paying someone back double to hide the reason for the payment, what are some things that they would not do? Well, they probably wouldn't tweet about reimbursing that person and wouldn't release the information on a government form. Trump, however, tweeted out in a 3-tweet thread that he reimbursed Cohen from his personal funds. He also explicitly says that the reimbursement is for Cohen paying for the NDA with Stormy Daniels. He also included in a footnote of a government ethics form that he is reimbursing Cohen. This disproves intent. The prosecution say that Trump created false documents to hide the payments. Trump clearly didn't care about hiding anything. The prosecution also claims that Trump was motivated to create false records to stop anyone finding out about women's stories about him, especially after the Access Hollywood tape was released. They say that his electoral prospects were seriously hurt by it, and that any new stories would be deadly to Trump's campaign. In reality, the Access Hollywood tape was just another of many negative stories about Trump, which were a huge deal for one day and forgotten the next. Trump knew this at the time. Madeleine Westerhout described Trump's reaction to the tape.
But before the transition, there was the Access Hollywood tape that you were asked about on direct examination, right?
Yes.
And you testified on cross that it rattled the RNC leadership, correct?
That's my recollection, yes.
There were a couple of days of consternation, right?
Yes.
That happened all the time during the campaign, right?
Yeah.
There's always some event that causes total consternation for a couple of days, right?
Yes.
And when President Trump was running for election, there was always some event that everybody said, claps twice, that's it, he's not going to win, right?
Yes.
And everybody around would be freaking out, right?
Yeah.
But not President Trump, right?
No.
He did not freak out about any of this, right?
Not that I was aware of.
He just kept his mind straightforward and kept running for the election, right?
Yes.
Trump wasn't desperate to cover anything up. He literally tweeted about the payment he was supposedly trying to hide. Intent definitely was not proven beyond a reasonable doubt. Wall 3 is not strong enough to convict Trump. So those are the 4 walls. And if, and only if, looking at both sides of the evidence, we find that the prosecution has proven every single one of these beyond a reasonable doubt, can Trump be found guilty. But we can also look at the general lack of evidence to get reasonable doubts. The defense already put forward arguments as to why Cohen is unreliable and should be disregarded. But Pecker has his problems too. Pecker has an agreement with the prosecution that in exchange for his testimony against Trump, he'll be immune from any charges arising from his conduct in this case. But if he lies, the agreement is void. Even if he tells the truth, but the prosecution thinks it is a lie, that is something that they would have to fight out in court. That's certainly a strong motivation to tell the prosecution what they want to hear. Even if they are not big lies, Pecker is motivated to maybe remember things in ways that help the prosecution and fit with their view of what the truth is. Knowing this, can Trump really be found guilty beyond a reasonable doubt on his testimony? The final reasonable doubt the defense put forward has nothing to do with the exhibits or the testimony in this case. They relate to the testimony that wasn't in this trial. Allen Weisselberg was Trump's second in command at the Trump Organization. The prosecution claim that he was intimately involved alongside Trump in the plot to secretly pay Cohen back. Weisselberg didn't testify in this case. Keith Schiller was Trump's bodyguard. He was supposedly a middleman through whom people could reach Trump when he was on the campaign trail. Through him, Cohen and Pecker spoke to Trump, allegedly illegally conspiring to influence the election. Maybe Schiller knows something. Maybe he doesn't. We don't know because the prosecution didn't call him. Gina Rodriguez was Daniels' agent. She played a huge part in negotiating the NDA alongside Davidson. We have no idea what she would say on the stand since she wasn't called by the prosecution. Eric Trump and Donald Trump Jr. literally signed 2 of the checks Trump is being prosecuted for. What was their knowledge about everything? We don't know because the prosecution didn't call them. And finally, we have Dylan Howard. Howard is basically the 4th honorary member of the conspiracy between Pecker, Cohen, and Trump. Howard did more than Pecker on a day-to-day basis when it comes to helping Trump for AMI. He was the key man that negotiated all 3 of the catch and kill deals. Now Howard was not called since he couldn't travel from Australia due to health reasons. But that doesn't matter. We can't just say, well, the prosecution has a sick note, so I guess we'll just find Trump guilty. It is the prosecution's obligation to bring evidence to prove it beyond a reasonable doubt. If some of that evidence is missing, it doesn't matter why. It has to be not guilty. So that's the defense's arguments as to why Trump is not guilty. Do you think they did a good job? Did they raise reasonable doubt in your mind? Or is there enough evidence the prosecution put forward in part 1, which the defense failed to refute? But remember, this isn't the end. This whole video was from the defense's perspective, putting forward their arguments. But the prosecution still has one more chance to respond. And we will see how they do that in part 3 of this series.